So now the judge in the Michael Flynn case wants to bring in another judge to help him decide whether he should grant the Department of Justice request to drop charges against Michael Flynn. Folks, this is all theater, a primer. There are two parties in every criminal case, the government and the defendant. Here, the United States and Michael Flynn. Criminal prosecutions are no longer conducted in the village square, where everyone holding their pitchforks gets involved and rallies for justice, usually delivered from the closest tree. Now, Judge Sullivan, you've been a judge for more than 30 years, and you now need another judge to co-pilot your way through this simple decision, a virtual ministerial request, where you check the box on a file and allow for dismissal of the charge, especially where neither the defendant nor the government disagree? This is difficult for you? It's done all the time. Don't you have law clerks who help you make decisions? Hell, at this point, why not just do a political poll? Now, as a judge, you were obliged to rule on the issue before you. The Attorney General has indicated the prosecution does not wish to go forward. He wants to right a wrong. And in that motion, the Department of Justice indicates there was no basis to investigate Michael Flynn because on January 4th, the FBI found that there was no derogatory information or evidence against Flynn that would even support an investigation. And now we know that corrupt FBI agent Peter Strzok started a new case without a predicate crime. On the fourth day in the White House, Cardinal Comey called Flynn to say he was sending in FBI agents. Comey openly admits he did so in violation of White House protocol and policy, and his deputy director McCabe said Flynn doesn't need a lawyer. But we now know from notes just released that Flynn was a target for the prosecution of a crime yet unknown. In fact, the FBI agents to whom Flynn spoke didn't think he lied, and the 302 notes of the interview were heavily edited by Strzok and his lover, Lisa Page, and amazingly, the 302 notes are now missing. Federal Rule 48A of the Federal Rules of Evidence, Judge, make clear that the decision to dismiss pending charges lies squarely with the prosecutor. The executive branch, the prosecutor, has exclusive authority and absolute discretion to decide whether to prosecute a case. And by the way, Judge, your comrade, Justice Ruth Bader Ginsburg, just this week, wrote for a unanimous Supreme Court eviscerating and reversing the Ninth Circuit Court for inviting outside counsel to brief on an issue not before them, just like you. Now, this thinly veiled effort to bring in another judge to argue against the government and Michael Flynn is nothing more than an effort to poison the 2020 voting electorate. Sullivan also wants to charge Flynn with perjury or lying for pleading guilty. Really? Should we charge every defendant who pleads not guilty with perjury if they're later found guilty? After all, it was a lie when they said they weren't guilty, and the court wasted its time, and the calendar was slowed down, and taxpayers suffered financially. But consider this. What about a defendant who pleads guilty because his lawyers pressure him, as was clearly done in this case, telling Flynn if he doesn't plead, his son will be prosecuted? What about the defendant who pleads because he gets a lesser sentence than if he goes to trial and he doesn't want to risk being found guilty even if he knows he's not guilty? Consider where there's new DNA evidence, exculpatory evidence like here, where the prosecutor has hidden Brady material. Should all of these defendants be charged with perjury when exculpatory evidence comes forward? In Emmett Sullivan's world, there is no review. What's done is done. Damn the evidence and damn the innocent. And Judge, how are you going to prosecute Flynn? Will you walk into the executive branch from the judiciary and pick a prosecutor to your liking? Or will you jump back and forth from behind the bench to in front of the bench, ripping your robe off to argue the DA's case? Have you not heard of the separation of powers? When you ask what additional charges can be filed against a three-star general railroaded by the corrupt Obama FBI and DOJ, then it's time to bring in a new judge. You actually asked if Mueller considered treason a death penalty-eligible crime when Flynn was only facing 5 years? You told General Flynn, quote, you sold out your country when the FBI files made clear Flynn had done nothing derogatory? Judge, where were you getting that information from? Who were you talking to? How could you go outside the file in front of you? Were you having communications with Strzok and Mueller's team not on the record and without the defense's knowledge? The law is clear. Decisions to dismiss pending criminal charges lie squarely with the prosecution. The only thing left is for the government to now seek a writ of mandamus from a higher court, forcing you to act as required by law. The government and Flynn's right is clear and indisputable. Judge, why are you dug in on a blatantly political prosecution? You have proven your agenda is not justice. It is the poisoning of the electorate and violating fundamental pillars of our criminal justice system. Underneath your robes is a hardened political operative, willing to ignore the law, precedent, and the separation of powers to punish a man wrongly framed and targeted by the Obama administration. God help us.